Okay. The Ninth Circuit U.S. Court of Appeals says no, it's not okay to carry guns in public without a license. This, of course, is not the whole story. It is not the accurate story, and it is not even coming close to explaining why this decision from the Ninth Circuit is not only wrong, but actually bad, and why the Supreme Court desperately needs to get off of their butts and take a Second Amendment case and clear this up, because apparently the courts in the back aren't listening. Let's talk about it. I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer, but I'm also a legal and political commentator here on YouTube. If you like that stuff, hit the subscribe button, hit the notification bell. Don't miss any videos. Okay, so what's happened here? This is about a case from Hawaii in which a guy wanted to carry a gun. Hawaii did not allow open carry. They had a process for issuing a conceal and carry permit. The problem with that process, which many states employ, and it is a perfectly acceptable legal way for you to have a carry permit process in lieu of recognizing constitutional open carry. There's a whole big debate to have there. By the way, this video is not the place for it. I believe that constitutional open carry is the proper way to do things. However, that is not what has stacked up across the country. Basically, you have to either have open carry or you have to have a reasonable permit process for people to have a permit to carry and exercise their right. Hawaii implemented a permit system, but it wasn't reasonable. And in fact, it basically became a pretext for denying the right to keep and bear arms that's guaranteed by the Second Amendment. What they said was, here, yeah, we have a permit process. Just go ahead and follow it. By the way, to go ahead and do that, you need to articulate to us a pressing need to have your right to carry a gun. And you're like, wait a minute, but my right is just that I have the right. I can carry a gun because the Second Amendment recognizes my right to keep and bear arms for the purposes of whatever I want, including defending myself in public or in private or wherever. That is the articulable need. And Hawaii says, nope, that's not good enough. You have to articulate a different need. And they use that to prevent the issuance of permits to basically anybody. You couldn't get one. So since you can't get a permit in Hawaii, this is what went to the appeals court. Guy said, I'm a law-abiding citizen. I followed all of the procedures Hawaii laid out. They still won't give it to me. Therefore, my rights are being infringed by the state of Hawaii. And he was right. And the Ninth Circuit Court of Appeals at that point, and I believe it was a split 2-1 decision, said, nope. If Hawaii is going to go ahead and have this scheme, but not honor that scheme and not honor the right, then we're going to go ahead and say that their scheme is unconstitutional and they have to recognize constitutional open carry. And so that's what was going on. So then what happened is this case came back on review en banc. That's where the entire Ninth Circuit, all of the judges get together and hear the case together, and then they have a majority vote. So the new vote is 7-4, and it says that Hawaii's scheme is basically okay. That's what's going on here. But in the context of that, they say that the government has the ability to regulate open carry in public. That's partly true, okay? We're going to get into this. But this is the problem that the Supreme Court has been avoiding for a decade. And this is the real issue here. This is why Clarence Thomas was right when he said that the Second Amendment has become a second-hand right in this country. There is no other right. There is nothing else in the Constitution where we go, you know what? Yeah, you need a permit for that. You need to go ahead and go through this arduous government process. You need to pay extra money to exercise your right. You have a right to a trial by jury. Imagine if the court put a fee on your right to a trial by jury and said, yeah, you can only get this if you follow through this process. Or if they made you apply and reasonably articulate why you needed a right to a trial by jury. Or maybe they need to reasonably articulate why you shouldn't have soldiers quartered in your home, or why you should have a right to an attorney, or why you should be free from unreasonable searches and seizures. Or how about that freedom from pain and suffering caused by torture? You know, that Eighth Amendment right against cruel and unusual punishments. What if the government could cruelly and unusually punish you unless you demonstrated a compelling individual reason why they shouldn't, Oh, and went ahead and did a training course and paid a fee. Then you could not be cruelly and unusually punished by the government, but only after you fulfilled these specific regulations. What if journalists needed to have a particular government issued license that the government could revoke at any time? No one would think any of those things are reasonable in any capacity. However, on the Second Amendment, oh yeah, of course you need a permit. Well, of course the government needs you to give you permission to have a right. No, they don't. That's not the proper way rights are dealt with in this country, but it is the way that we have to deal with them because that's how courts have stacked up on it. And the Supreme Court needs to step in. They need to be led by someone like Clarence Thomas, and they need to go ahead and address the reality of Second Amendment rights by addressing the language of the text and getting rid of all this bogus nonsense that's been coming out of various appeals courts, and in particular, the Ninth Circuit. Let's take a look at this article. It's from the San Francisco Chronicle. You can read it down in the description below. There are not a lot of articles out on this because this is really, really fresh, but I wanted to get this story out today. So it says states can prohibit people from openly carrying guns in public. A federal appeals court ruled Wednesday, adding a voice to a heated issue that the U.S. Supreme Court may soon address. And they have to. They have to do this. Appeals courts are split on this. They need to go ahead and address this. Now, there is the ability for the government to regulate where you can carry a gun. It's a time, place, and manner restriction that would apply to the First Amendment and others. This is different from the permit requirement. That's a whole separate thing. But there is an idea of reasonable restrictions when certain conditions are met. For free speech, it's strict scrutiny, where the government must show a compelling government interest and a solution that is reasonably tailored to only and minimally impact the right to this, limited to this compelling government interest. Okay, so that's how speech is dealt with. If a government has a statute that facially restricts speech, it needs to meet that compelling interest test of strict scrutiny. They've never established what level of scrutiny is appropriate to the Second Amendment because it's very uncomfortable, but it's basically got to be strict scrutiny. As Justice Scalia laid out in DC versus Heller, the Constitution didn't create a right to keep and bear arms. It recognized a pre-existing right to keep and bear arms, a right that you have inherent to you. This is not a constitutional right. It's a human right to carry the tools necessary to defend yourself from harm and confrontation caused by someone else. That's the Second Amendment. It's not related to the military. It's not related to a militia. It's not anything to do with that. Your right to keep and bear arms is inherent to you, not because a government says so, but because it's already inherent. That's the whole point of inherency. So, Scalia had laid this out, but time and time again, various courts have tried to curtail that right. Various statutes have tried to curtail that right, and gun control is a huge topic right now. In a 7-4 ruling, Ninth U.S. Circuit Court of Appeals in San Francisco upheld a Hawaii law that bans residents from openly carrying firearms without a license, which is issued only to those who can show they need the weapons to protect life or property. Police and members of the armed forces are exempt. California also requires open carry licenses, which are virtually unavailable in the state's most populous counties. So this is the problem. If you can't get them, then you don't have a right. If they're not guaranteeing the right, then the state is acting in an unconstitutional way. That's the way it goes. It's been that way since the 14th Amendment. The 14th Amendment applies the Bill of Rights to the states, and guns are no exception. And if it wasn't resolved yet, it was definitely resolved in DC versus Heller and in McDonald versus Chicago back in 2008 and 2010, respectively. Quote, our review of more than 700 years of English and American legal history reveals a strong theme. Government has the power to regulate arms in the public square, Judge Jay Bybee, one of the appeals court's most conservative members, said in the majority opinion. There is no right to carry arms openly in public, nor is any such right within the scope of the Second Amendment, Bybee said. It remains as true today as it was centuries ago that the mere presence of such weapons presents a terror to the public, and that widespread carrying of handguns would strongly suggest that state and local governments have lost control of our public areas. That is not at all correct. That's not at all accurate. And I'm sorry, but state and local governments don't have control over public areas. They may have control over certain public buildings, but they do not have control over public places, parks, streets, sidewalks. Those sorts of things are all public spaces. And if you are able to unfetteredly restrict rights within public spaces, then there is no right. And of course, he's generalizing what is being said here, but I vehemently disagree with this judge. And I would encourage the judge to go back and read DC versus Heller and read McDonald versus Chicago, because they would suggest the opposite, that the governments can regulate, but that the right must still be secured by the government through some sort of other scheme, like a carry permit of some sort. And those carry permits must be meaningfully issued, not unreasonably restricted. That's the problem. That's the problem here. Again, the right of the government to regulate doesn't mean that the regulations have the ability to erase the right. Yes. It doesn't mean that the government can regulate, so therefore it can erase and obviate the right. No, that is not how it works. That's never how it's worked. That's not how it works in any capacity for any other amendment. Only this one. In dissent, Judge Diarmuid O'Scanlan, I don't know how to say that name, said the right to keep and bear arms declared in the Second Amendment must include, at the least, the right to carry a firearm openly for self-defense. He was joined by Judges Consuelo Callahan, Sandra Ikuda, and Ryan Nelson. The ruling comes as the Senate debates background checks, blah, blah, blah. The Supreme Court ruled in 2008 that the Second Amendment allows Americans to possess handguns at home for self-defense, but has not decided whether it allows carrying firearms in public. If you read that 2008 decision, it is not limited to the home. The case before them was limited to the home because the case was about in Washington, D.C., they required you to keep firearms in the home disassembled. So you couldn't have a handgun assembled in your home. So it was completely meaningless to have a handgun basically at all for self-defense purposes, because if someone's trying to kill you, they're not going to wait for you to assemble your gun first and make sure it works. That's not how killing goes, apparently. I don't know. Maybe the Supreme Court's crazy there. But that's what was going on. So just because the case was limited to a law restricting firearm ownership in the home does not mean that the principles of DC versus Heller say, well, we don't know about the public. It's pretty clear that when Scalia is talking about the right to bear arms, including the right to actually carrying arms with you for the purposes of potential confrontation, that he's not talking about in your home. He's talking about everywhere. That's the right. There has to be a meaningful right to carry. However, that is implemented and regulated by the government must be addressed under the appropriate level of scrutiny, which Scalia was hesitant to assign, and why the Supreme Court needs to address this. They need to determine the level of scrutiny, and it really should be strict scrutiny like any other enumerated and inherent right. But let's go on. When the Ninth Circuit upheld California's ban on publicly carrying concealed handguns in 2016, Supreme Court denied review of an appeal by gun advocates and left the ruling intact. That's because the Supreme Court has been cowards on the gun issues for a decade. Appeals courts have reached diverse conclusions on state laws banning openly carrying handguns, and the High Court could decide next week whether to take up the issue in an appeal of a ruling upholding a similar law in New York State. Alan Beck, a lawyer for the gun owner who challenged the Hawaii law, said he would also seek review by the Supreme Court to overturn the Ninth Circuit's erroneous decision. Attorney Eric Tershwell of the gun control group Everytown for Gun Safety said the ruling was the latest reminder that arguments against reasonable life-saving gun laws rarely hold up in the courtroom. These aren't reasonable laws. That's the problem. You have a problem because you don't like the right. Well, amend it out of the Constitution then. Try it. Try it. A smaller panel of the appeals court had declared the Hawaii law unconstitutional in 2018 in a 2-1 decision by O'Scanlan, but a majority of the full court voted to set that ruling aside and ordered a new hearing before a larger panel. Bybee, in Wednesday's ruling, said the meaning of the Second Amendment could be traced back to English law, which as early as 1299 requires citizens to obtain a license from the king to carry arms in public. American colonies started adopting similar laws in the late 17th century, he said, and most early state laws banned carrying guns in the public square. Sorry, though, that's fine and dandy, but we passed a 14th Amendment during Reconstruction that applies federalism. It applies federal laws to the state. Well, federal rights, federally recognized rights to the states. It no longer allowed states to curtail rights. There's a minimum bar of entry, and that is the U.S. Constitution. So you may not like it, but this is an improper read by the judge. The heart of the Second Amendment is defense of hearth and home. False. False. It's defense of person, not hearth and home. Quoting language from the Supreme Court's 2008 ruling, the power of the government to regulate carrying arms in the public square does not infringe in any way on the right of an individual to defend his home or business. Now, importantly, that second quote is not quoting DC versus Heller, because you won't find that in DC versus Heller. But O'Scanlan, in dissent, said the court majority reduces the right to bear arms to a mere ink blot. And that is the problem. That is the correct thing. When a right is words on paper and never upheld by the government, it is no longer a right. It's just a platitude. And that is not acceptable. If you don't like the Second Amendment, amend it out. Until next time, peace. Peace.